attorney's office.
And most of the clients that come to you, I'm going to assume that the only piece of property that they own is the home they live in, for the most part, right? And they have some retirement accounts.
Right.
And they probably have a lot of debt.
That's right.
And so would that be a Chapter 7 candidate for a client?
Well, as long as they meet the qualifications under the means test, as you know, when a Chapter 7 case is filed, a Chapter 7 trustee is appointed, and they can take certain property to be liquidated for the benefit of your creditors. Now, to tell you the truth, most people who file Chapter 7 don't lose their home, they don't lose their personal property, or they can make arrangements to keep everything. But under Florida law, for example, a person's homestead is their castle, so the trustee cannot liquidate somebody's homestead. And household goods and furnishings, they just don't want to take because nobody is buying secondhand furniture. The third thing is qualified retirement accounts such as 401ks, IRAs, and annuities, which are used for retirement, are not something that can be liquidated for creditors. In other words, the debtor gets to keep all that property.
And then the other thing people typically own is a car. So what typically happens with somebody's car when they file a Chapter 7 bankruptcy?
Most people are upside down in their automobiles when they file a bankruptcy. That is, they owe more on the car than what it's worth. But if they have equity, you're allowed $1,000 equity per person, which means in a family, husband and wife who file, they get to exempt out $2,000. And if they're a little bit over that in equity, the difference between the value of the car and what they owe on the car, generally a Chapter 7 trustee will take some payments over time or make some kind of arrangements so that they can keep their car for going back and forth to work.
So if we talk about a car that's upside down, a typical client comes in and sees you, and they have a car that they owe $20,000 on. The car is only worth $15,000. Would your typical client keep that car or give it back to the bank?
Well, if they owe 20 and it's worth 15, it's up to them based upon their budget whether or not they want to continue with the automobile or whether or not they want to surrender it to the bank. If they surrender it to the car finance company or the financial institution that has financed it, the debt goes away. And if they want to keep the vehicle these days, they may have to reaffirm the debt, and that is tell the finance company that they want to keep the debt and the car.
Would a reason for them to keep the car, even if it's worth 15, they owe 20, would be as if they give it back to the bank, it would be difficult for them to go buy another car once their bankruptcy is finished?
That's a hard question to answer these days because the way that the market and everything is working, I've never had a client come back and tell me they couldn't secure other transportation if they gave back a vehicle, but that is a concern.
All right. And so then let's talk about the house, because a lot of people must come to you these days and they're upside down.